group to come together and look and develop a policy around how we were going to make that happen and what that would look like. Although stay tuned, because that's changing due to changes in the way we're doing toxicology testing in Colorado. So we'll be redoing that policy, but that was kind of where it started back in 2011. Out of that, we realized there were a number of issues that we needed to take a look at with regard to forensic compliance. If you all remember, I'm hoping you all know and remember, in 2005, the federal government passed a law within the Violence Against Women Act saying that sex assault, for the first time, saying that sex assault victims could get a medical forensic exam without having to participate with law enforcement or any kind of criminal justice system investigation. Every state, if they wanted to continue receiving their VAWA funding, had to pass a similar law or a corresponding law. Colorado passed our law in 2008. So since 2008, this has been true for victims in Colorado. We refer to those victims in Colorado as medical reporting victims. What we wanted to do as part of this FCEP, this Forensic Compliance Evaluation Project group, which is a fabulous name, what we wanted to do with that was take a look at, since 2008, we'd gone for 3 years, and we wanted to see how the implementation was happening across Colorado. So we continued this group, and these are the things we started to look at. Also, before I move on, I just wanted to quickly say the Division of Criminal Justice Office for Victims Programs, we pay the evidence collection costs for medical reporting, and now since passage of 128, anonymous reporting victims. And we also, since CCASA passed the SAVE, Sex Assault Victim Emergency Payment Program, in 2013, we can pay for associated costs. I'm hoping that all of you on this webinar know that. But if not and you need more information, my contact information is at the back. So we're able to pay up to $3,000 of medical costs for sex assault victims who are choosing to not engage with the criminal justice system at the time of receiving medical care. So I just want to make sure I got that in. Moving on. To find out how we were doing and how the implementation of the forensic compliance laws from 2008 were working in Colorado, we decided we would, we conducted a survey, and we also did an analysis of some kits. That survey, if you want to read it in its entirety, which is riveting, can be found on CCASA's website. But for our purposes today, one of the things in our survey, we asked 239 multidisciplinary professionals if they had encountered a victim who wanted to remain anonymous. And over half of them had encountered at least one victim who wanted to do that. We thought that was an interesting and startling response, considering the fact that in Colorado, anonymous reporting was not ever offered as an option. In 2008, when we created our VAWA compliant law, we didn't create an anonymous reporting option. Many states did, Colorado did not. Hence, we came up with that kind of hybrid medical reporting, in that they're reporting for medical care, and those kits are given to law enforcement. So obviously a report is made to law enforcement, but it's done through our medical mandated reporting law and not through the victim themselves. So it was an interesting hybrid where the victim's name and contact information was generally given to law enforcement. Some communities did. Well, one that I know of kind of did try to create an anonymous reporting system, but statewide that wasn't an option. So we thought that was a relatively significant finding. At the same time, those states that had created anonymous reporting and other states that were doing things above and beyond that, results were starting to come in on anonymous reporting and success that communities were having with anonymous reporting, both in terms of victim outcome and in terms of law enforcement engagement. Some states, and in particular, I think the most studied at this point entity is the You Have Options program out of Ashland, Oregon. But anonymous reporting, it turns out, actually removes a number of barriers, not surprisingly, for victims to actually report to law enforcement on some level, whether it's anonymous or not. But what law enforcement was finding in these communities where this was happening was that they were getting a lot more information than they otherwise never would have gotten. So they were able to identify patterns going on in their community and start to look a little bit further and a little bit deeper beyond just one perhaps anonymous sex assault report. So they were finding they were getting all kinds of information they otherwise wouldn't have gotten. As you know, victims tend not to report because they don't think they're going to be believed. They don't want to get the offender in trouble. They're embarrassed over what happened. These are the barriers that if they can report anonymously, they'll go ahead and report, and this is the information that law enforcement can then use to identify patterns. As a result of anonymous reporting, reports in communities that they're doing this, reports are up, there's better identification of serial offenders, and more successful prosecutions because the information they're getting on the front end is actually better. So basically what we learned from other communities that were doing this, anonymous reporting plus advocacy involvement is an important aspect of this. And I think we're going to go into that later. And then also a trauma-informed response. If you have those three elements involved, your outcomes both on the victim service side and the criminal justice side tend to be better. So given the survey results and what we knew nationally, we wanted to take a look at anonymous reporting in Colorado. At the same time, we had also asked about our medical mandated reporting statute, because that tends to fly in the face of anonymity, or it certainly had been the way we had constructed this from 2008. Interestingly, the survey showed general support for the law across all disciplines who responded, which surprised us, quite frankly. But what it also showed in the comments section was there was significant confusion about the law and what it meant and how it was being handled. What we learned is that even within the same jurisdiction, people were treating this law very differently for sex assault victims. And so we thought, well, clearly we need to look at the way this is clarified. And frankly, our medical mandated reporting statute did not specify sex assault as something that needed to be reported. It fell into a broad category under other injuries that are suspected to be the result of criminal activity. So as you might imagine, in addition to the confusion comments, we also got comments, and you can see where the confusion comes in because comments or suggestions for revisions came down to revisions, totally eliminated, or add to it. So people were all across the board on this. So our forensic compliance team talked about this and said, you know, we need to actually take a look at cleaning this up for sexual assault.
Okay, so we're going to take a look at, just briefly snapshot, what this statute looked like before Senate Bill 128. So again, this is the statute that Terry was just talking about that we surveyed in the forensic compliance report and found that people were just all over the board, different interpretations, and that we really did need to do some cleanup work to make sure people knew what the heck was required under it, frankly. So prior to Senate Bill 128, these are sort of what I see as three components of the statute, and there's really a lot to unpack with this slide. So I'm going to talk through each of these points and considerations. So this statute is written for medical licensees, and that in itself is a confusion point because it's been interpreted to apply to much larger medical professionals than who is specifically enumerated in the statute. And I'll say that, you know, there are statutes that are subject to interpretation and that sort of thing, but this is actually quite clear. This statute applied to medical licensees who were very clearly defined in that statute as a physician assistant, or an anesthesiologist assistant. So those are the three entities that were responsible for this mandatory reporting obligation. And what it says in that statute is that these specific medical licensees must report to law enforcement the treatment of injuries believed to be caused by a crime. So sit with that for a minute and then we'll kind of unpack it a little bit. So the way that the statute is written is it enumerated certain crimes. So it listed some out, you know, such as gunshot wound, stab wound, you know, talks about an ice pick wound, talks about a dangerous dog bite. So it, you know, lists out very specific types of crimes. And then but it also had this sort of umbrella piece to it that also mandated a report for domestic violence and then any other treatment of injury that's believed to be caused by a criminal act. So, so that's what the statute essentially consisted of. So just to sort of unpack it, you know, we had heard, you know, frankly, that there's certainly, as I mentioned, confusion about who this even applies to, and folks interpreting it to apply to much broader medical professionals when really the statute was quite clear. This applies to physicians, physician's assistants, and anesthesiologist assistants. But beyond that, so initial confusion about who does this even apply to, then there was confusion around, or kind of philosophical challenges around this whole piece of the medical professional determining if an injury was caused by a crime. So there were certain medical professionals, you know, who would say to us about this statute, my job is to provide health care, you know, and treatment for injuries, certainly. It's not my job to investigate or determine criminal activity. So there was sort of a philosophical challenge with some of this as well. It's also important to really clarify that this statute applies as it was written to competent adults seeking health care. So, when we first surveyed folks about mandatory reporting requirements, they immediately in our survey started talking about how important they are for children. And we certainly agree, but what's important to point out about this law in particular is this is not just specific to children. This is any treatment of any injuries believed to be caused by a crime. And having this type of law that applies to competent adults seeking healthcare was really, it's not a norm nationwide. Colorado is one of 9 states that had this approach for adult patients who were seeking medical care. Really largely what we see nationally is that best practice is typically to provide victim choice regarding some law enforcement interactions, although, this does look different in every state. So I should clarify that Colorado is one of 9 states that had a requirement that could apply specifically to sex assault victims. So yeah, those were some challenges that came up, and then oddly enough, you would think this term injury is pretty clear, but when people look at statutory interpretation, we got a lot of comments that oddly enough, injury can be a subjective term. There are folks who sort of on one side of the spectrum took anything as like emotional injury was reportable, all the way to the other end of the spectrum where folks said, I interpret that to only mean serious bodily injury, which is much more extensive and, life-threatening. So there was this huge spectrum of how people were even interpreting what injury meant. So, with all of this sort of dialogue we were having, as well as sort of being coupled with this information we got, the service professionals were hearing from victims wanting to remain anonymous, we felt that it was time to sort of tackle this statute, essentially. Okay, so we were just looking to see if we had any comments or questions at this point. Oh, let's see, okay, sorry about that. So, briefly, just wanted to touch on this revision process. As Terry said, we convened the forensic compliance team in 2011. So this work has actually been a few years in the process. It wasn't something that we came to right away, introducing Senate Bill 128. There were a lot of steps in the process. So, we launched this statewide survey. It was quite an effort to analyze the survey data, especially for Terry and I, since we're not researchers. So we did have to consult with some researchers. We had a lot of stakeholder meetings where we were meeting with medical professionals, meeting with law enforcement, meeting with advocates. And then we worked within 2 different committees with the Forensic Compliance Team and the CCASA Public Policy Committee to draft legislation that really clarified the statute specifically for sex assault. And the reason that's underlined on your screen is we feel like that's a pretty important point of all this work. It wasn't our purview at the Colorado Coalition Against Sexual Assault to determine what happens when there are other treated injuries believed to be caused by a crime. Like, for example, CCASA shouldn't determine what happens when a patient presents with a gunshot wound, for example. So we felt like it wasn't our purview to completely rewrite this statute, but we felt like we did have a place to work with stakeholders to clarify it specific to sex assault. So that works really well, frankly, for patients that are presenting just for sex assault. It can get a little bit tricky when there's a patient who presents with sex assault but then also has other injuries caused by other crimes. So sometimes those things can be intertwined, and we're going to discuss those scenarios later. Okay, so really, I just wanted to frame our overarching goal of the statutory revision. We did talk about how clearly there was a lot of confusion about it and it wasn't being interpreted uniformly around the state, and we felt that had negative impacts for patient care, frankly, if folks didn't really know what they were supposed to do or how to do it. But beyond that, there's just some things that we know about sex assault that we felt like really could sort of infuse and intersect with our work around the statute. And the reality is that sex assault is one of the most underreported crimes in the United States. Victims don't come forward. They don't often get medical care. They don't even learn about their criminal justice options. And that can actually have long-term mental health symptoms, post-traumatic stress, all sorts of outcomes can come from victims not feeling like they can get help or not feeling like they can engage. So really, one thing that we've seen nationally, as Terry was talking about, since the Violence Against Women Act reauthorization in 2005, is that when adult victims, and that's who we're talking about with this work, because we know things look differently for minors or at-risk adults. But when adult victims have choices and options, we find that they're more likely to engage in various systems. They're more likely to get health care. They're more likely to possibly have evidence collected, and more likely to learn about their criminal justice options. So really, we were looking at how can we create a system that is easier for victims to access and easier for victims to approach, because certainly coming forward after a sex assault is incredibly daunting and intimidating. So what can we do to make it a little bit more victim-centered? And that can be really important, specifically with sex assault, because we know it's a crime where power and control were taken away from the victim and removed from the victim. So we can start to restore that power and control by giving victims some choices about how they move forward. And I guess one other thing I would just mention really quick is sort of infusing what we know about perpetrators into this conversation. We know that perpetrators of sexual violence often target victims who are vulnerable, accessible, and lacking in credibility. But we know that those victims, those may be the victims in particular who are really nervous to engage with the criminal justice system, and who may want to look at options of getting care and even speaking to law enforcement anonymously. So maybe a victim who's undocumented, a victim who was using illegal drugs at the time of the assault, a victim who had previous had been arrested themselves in a crime. And so we know that not every individual, not every community feels safe and able to work with law enforcement. So we really thought that just kind of looking at how we know that perpetrators target that population, it can be really important for all victims to be able to access care and to have some safety around doing it. Okay, so that was sort of our first piece about the overarching goal of the statutory revisions. But and I've said this just while I'm talking, but I felt like it needed a slide on its own. I wanted to just go ahead and put out there that with Senate Bill 128, we did not change any other mandatory reporting requirements that exist under Colorado law. So the statute affected by Senate Bill 128 is not the only mandated reporting statute. So you have the citation on your screen. There's a mandatory reporting requirement for minors, which are defined as under 18 in Colorado law, as well as a mandatory reporting requirement that's newer, frankly, for at-risk elders, and that's defined as an elder who's 70 or above. Just this legislative session in 2015, some legislation passed to create a mandatory reporting requirement for adults that have an intellectual or developmental disability. That law did pass, but it won't go into effect until July 1st, 2016. But this work we did under Senate Bill 128 doesn't affect those other requirements. So I think that's important for folks to know, and certainly to know that evidence for those populations, evidence can't be stored anonymously, because those pre-existing statutes that I just mentioned, they require a report to law enforcement that contains victim identifying information if available. So we do get asked, and this could be something we could do some questions about in the chat box later, do these populations have the ability to be a medical reporting victim? So that option Terry talked about, where they get evidence collected, they receive medical care for a sex assault, law enforcement, evidence is stored under their name. Law enforcement typically has their contact information, but they don't have to participate in the criminal justice system, and certainly the care is at no cost to them. Our interpretation, our reading of the statutes are that yes, an at-risk adult can be a medical reporting victim. Minors are really tricky on this issue. We have kind of a array of statutes around minors accessing medical care. Frankly, if there's different investigation sort of obligations if law enforcement's aware of a minor that's being hurt. So it's unlikely for a minor, but we have seen some cases where they have been able to have that option. So it's really sort of a case-by-case basis with minors. And that's something that either one of us can also sort of walk through with you if helpful. Okay, so that's a little bit of our background. So we're going to jump now into what are the changes under Senate Bill 128. So essentially, Senate Bill 128 gave us two categories. So you could say two categories of cases, two categories of victims. So in your left corner, that's sort of category one, and that would be really what sort of separates our categories is this evidence collection. And we'll talk that through so you'll kind of see why that's the dividing line. So sort of category one are victims that request and have evidence collected. So if there is evidence collected, then there will be a report to law enforcement. And the easiest way for me to explain that to folks is frankly just around thinking about that evidence and chain of custody. If there's evidence collected, via a rape kit, that rape kit has to be tracked and we have to know where it is. And in Colorado, the hospital's not going to hold on to it. The victim doesn't get it. In Colorado, the system in place is that if there's evidence collected, then law enforcement with jurisdiction over the crime stores that evidence. So they have the custody of it. So if you think about it in that way, if evidence is getting collected, law enforcement is somehow going to be involved. What we did through Senate Bill 128 is create some options within that framework. So that's sort of column number one on the left. On column on the right, number two, this is where we're talking about victims who do not have evidence collected. So, evidence collection isn't something that all victims are going to want or request. There's certainly victims who just want to make sure that they're physically okay. Sorry?
Nor is it appropriate all the time.
Exactly. So evidence collection doesn't make sense for every victim in every case and every time. So for those victims, a report is not mandated unless a licensee. So again, I think it's really important for folks to know in terms of statutory obligations, what are you bound by Colorado law? Licensee is pretty limited in scope. As I said, that's a physician assistant, or anesthesiologist assistant. So a report is not required unless a licensee treats injuries that are believed to have been caused by a crime. And so we're going to flush that out some more, or there's other mandatory reporting statutes that apply, the ones we just discussed for minors and at-risk adults. So those are sort of our two situations, evidence collection, law enforcement report, however, options within that, no evidence collection, no report, unless, and then there's sort of the criteria you have. But through all of this, I think it's really important that it's framed as victim choice. That's pretty paramount to this statute. And we're going to sort of talk through the different points of where victims are making these decisions. Okay, so we're going to start with talking about victims with evidence collection. So out of Senate Bill 128, essentially there were three types of options. So if a victim says, yes, I want evidence collected, I want to, have a rape kit done, then they have the choice. They can be one of three types of reports can be made at that point. And it's up to the victim to choose one of three of those options. So the first two options that you all see on the screen, I just want to start with saying these options already existed under Colorado law. Senate Bill 128 did not create these. This was existent law that actually had been in place since 2008 in Colorado. And it was interesting for us when we were having conversations about the passage of Senate Bill 128, how many questions we got about these options, particularly option number 2. And we had to say, well, that's actually been existing law since 2008. So clearly there's continual opportunities for education around all of this. And that's why we have the forensic compliance team. But anyway, so the first option is pretty standard. This is a victim who wants to work with law enforcement. So victim, chooses to work with law enforcement at the time of medical care and evidence collection. Typically the evidence, evidence testing is also something that's based on victim choice and victim consent in Colorado. But this is your victim who's working with law enforcement. That's pretty much what you need to know about that report at the time of getting the evidence collection and medical care. The second option is what Terry talked at the beginning. Again, we've had this since 2008. This is where a victim chooses not to participate in a law enforcement investigation at the time of medical care and evidence collection. They still have a choice of whether or not they want that evidence tested. But what to know is that local law enforcement does receive that evidence, since that's who stores and receives evidence in our state. But it's stored under the victim's name. So law enforcement is typically, going to receive a rape kit that has a label on the front that has the victim's name. They also typically have the victim's contact information. Again, the victim is not participating in the criminal justice system, but that information is transparent.
Just as an FYI, also, the evidence being tested upon victim consent was a result of House Bill 1020 from 2013 as well, which was the rape kit testing bill. And just, we can tell this is a very small sample survey, but so far it looks like, because we pay for the evidence collection in our office for that, it looks like about, I'm going to say 20 to 25% of medical reporting victims choose to have their evidence tested. Just as an FYI.
And I know there's probably some questions around this whole evidence testing piece, which is a little bit out of the purview of the Senate Bill 128 webinar, but Terry and I worked really closely on that effort too, so we're happy to answer any questions about evidence testing. I mean, frankly, what you need to know about that too, again, based on victim consent. But at the end of this webinar, we have a slide where we're going to talk about implementation tools. So I can also show you where you can find more detailed information about evidence testing as well. Okay, so again, we have 3 options for victims who are having evidence collected. Work with law enforcement, not work with law enforcement, but their name and information is still transparent. What Senate Bill 128 did, or one thing that it did, one component is that we created a 3rd option, which is essentially an anonymous report. So this option is very similar to medical reporting. Really, the only difference for practical purposes is that the evidence is being collected and stored, or the evidence is being stored under a unique ID, a unique tracking number. So this is a victim who doesn't want to participate in the criminal justice system, says I want evidence collected, yeah, I want to have a rape kit done, but a lot of times, this would be somebody who just really needs more time to think about their options. This would be somebody who, frankly, doesn't feel ready to engage with law enforcement and may have some concerns about law enforcement having their name and contact information. So the law absolutely stipulates, it's in the law that a victim absolutely can choose to have an anonymous conversation with law enforcement because we think it's really important. We're talking about, when a victim is getting medical care or evidence collection, they're in an acute trauma state. And having to talk to law enforcement at that time can be really, really intimidating. So being able to say to a victim, it's up to you whether or not you want to have that conversation. If you do, then, you tell what you want, and it's up to you whether or not you want to share your name and that sort of thing. So essentially, a way that it can be framed is the patient is essentially a Jane Doe or a John Doe to law enforcement until they choose to give identifying information. And I think one thing that I would say is that because we know that the victim community is such acute trauma, again, sort of how we talked about restoring the steps of power and control can be really important. But we also know that, there can be a lot of opportunities for law enforcement to start to build trust, to start to gain rapport, for a victim to start to learn about their options in a way that feels safe. Something that we can also talk about is, since we've had this medical reporting option since 2008, we've been able to study essentially case conversions. So victims who at first didn't want to participate in the criminal justice system, but then later changed their mind and did. And one thing that we see about case conversions is that they can happen pretty quickly. Oftentimes it's within, 24 to 72 hours where the victim eats, the victim sleeps, they go home, they talk to friends and family, and then they say, okay, I actually do want to talk to law enforcement now. So I guess I want to bring that up just in that even if a victim wants anonymity initially, with law enforcement, that can change, it can and does change pretty quickly once a victim maybe starts to feel safe. So the other piece that differentiates anonymous reporting from medical reporting, so kind of the piece one is evidence is stored by a unique identifying number, tracking number, and not victim identifying information. The second piece is that anonymous reporting victims do not have the ability to have their evidence tested. And I could go into the reasons for that if it's of interest, but basically when a kit is tested, sometimes there's need for follow-up about what the results, and that's impossible to do if the victim is anonymous. So medical reporting victims can have their kits tested, And that sometimes can be an information point for them to help them determine whether or not they want to convert a case. But anonymous reporting victim, it's just evidence storage unless or until they want to provide some victim identifying information.
A couple of questions we've got in the early implementation stages around this are, one has to do with, there was some concern that, and this was also true while the bill was going through the legislature, is the anonymity is between the victim and law enforcement. There is no anonymity between the victim and the medical provider. The medical record is the one place where both the name and the unique identifying number live together. So even the victim will get a copy of paperwork. The consent form will, if it's not already, will be in the kit. They're available online right now. We'll have that unique identifying number on it. If they lose their paperwork, all they need to do is contact the hospital where they got the exam. If they need to know the numbers because they're choosing to convert and report to law enforcement. So the medical record contains both. It's the one place where both are contained. That's one question we've had. The other one is, what kind of unique identifying number? You know, communities that have interaction with military have already figured this out because of the restricted reports in military are also anonymous. So they've already figured out systems. This was left very open in the legislation so that communities could work this out on their own. But we think it's important to point out at this point in time, based on some of the information and questions we've gotten, that there are some unique identifying numbers that probably shouldn't be used and some that are a little easier to use. The obvious and probably easiest one is a case number. I mean, it's already assigned to it. It is already a unique number. And it doesn't identify the victim in any way except that case number. So that's one option. You could use numbers that include the date, you know, the date of the exam and something, not the patient's initials. You could also just, it could be a random number, Jane Doe 1, depending on the size of your community and how many of these you get. You could just do some kind of random numbering system. As long as the information in the medical record, the information that's given to the victim, and the information on the kit that's given to law enforcement all match, it'll be fine, whatever number you use. Numbers not to use, victim social security number, anything that identifies the victim personally, some part of the victim's email address or the email address, something that has to do with their home address, anything like that. I know some jurisdictions were looking at using things like that because it's easy for the victim to remember. Again, remembering really isn't essential here because it will be in the medical record. So what's more essential is that it be a truly unique number that doesn't in any way identify the victim. So if you have questions about that, you know, feel free to type them into your chat box and we'll take care of those as we go.
Awesome, thank you. So we have this sort of two outlining, you know, what Senate Bill 128 does. So we've got, you know, victims who have evidence collected, and we just walked through the three options that they have if they want evidence collected. Something else that did change under Senate Bill 128, as I mentioned, that statute only applies to physicians, physician's assistants, and anesthesiologist assistants. That's who had this mandatory reporting requirement. So Senate Bill 128 did make a change where we added nurses only to that, only to cases where there's sex assault with evidence collection, because in many parts in Colorado, as you all know, sex assault nurse examiners, nurses who have some forensic exam training, are primarily responsible for sexual assault evidence collection and patient care. So, oh, sorry, we've got some questions popping up. So for that reason, since we had nurses who were providing that really specialized services, nurses were added to this statute, but only in one place. And that's really important for folks to know too. Nurses under Senate Bill 128 are mandatory reporters for sex assaults with evidence collection. And the reason why, again, that nurse can't just keep the evidence, right? She's not going to take it home with her or put it in her locker. It has to be turned over to law enforcement. So because nurses are the ones who are doing that evidence collection, it made sense that they would be essentially reporting to law enforcement. And that was already happening in practice, but we felt like it was a distinction that needed to be made. We did not add any new mandatory reporting obligations to nurses. According to this law, that's the only thing a nurse is obligated to report under this statute. sex assault, with evidence collection so that that evidence can be turned over. There could be other hospital policies at play, and that's something we can talk about later, but for the purposes of the statute, that's really nurses' only sort of enumerated obligation that's listed out. Okay, so we walked through Senate Bill 128 for victims with evidence collection. So the other option is what happens when we have victims without evidence collection, because as we were saying, evidence collection isn't something every victim wants. It's not appropriate for every victim. So we really wanted to flesh out what that looks like. So what Senate Bill 128 says is that for cases in which a patient receives sex assault medical care, but no evidence is collected, a sexual assault report is not required to be made to law enforcement. So you have a note in the bottom right, essentially just saying that this approach is consistent with a 2003 Attorney General formal opinion of the interpretation of this statute. So we felt like, this is consistent with how folks had already viewed the statute, because as I mentioned, that statute is very specific to the treatment of injuries. So as we said, this is kind of our overarching premise that if it's just medical care and no evidence collection, then a report is not required to be made to law enforcement. However, because this is policy and statute, it's not that clear of a line, and there's a couple exceptions. But what you sort of need to remember around this, again, is this whole piece, the statutory definition of a licensee, who this mandatory reporting even applies to begin with, and that we didn't change for those licensees other obligations. So we're going to walk through some scenarios to help sort of flush this out. But we didn't get rid of, if that licensee, the obvious example, was required to report a gunshot wound, they still do. So that wasn't changed. But for a patient who's just getting medical care, no evidence collection, it certainly doesn't have any other treatable injuries, and doesn't fall under statutes for specifically applying to minors or at-risk elders. So sort of if you kind of cover all those caveats, then a report is not mandated.
Right. The only other thing I would add to that, as Karen said, we didn't change the medical mandated reporting statute. If a doctor has to report a gunshot wound, they still have to report a gunshot wound. I think it's important, and Karen stressed this, but I'm going to stress it again in a different voice. If we added nurses to the sex assault reporting requirement, they're not added to any other part of the medical mandated reporting statute, which they weren't involved with in the first place. So none of that changed. We've gotten a lot of confusion about that, but I think there was a lot of confusion about this statute to begin with. Who it applied to, what was required to be reported, how people interpreted injury, how they interpreted believed to be caused by a crime, so forth and so on. So we didn't change any of what existed before, except that we did add nurses to the new sex assault subsection. Also, I just want to remind everyone, because we've gotten a question about it, this is a train the trainer presentation, so feel free to use this in your own communities or for trainings you're conducting. If you have questions about it as you're going through it, feel free to call either one of us or email us. Again, our contact information is in the back. I know probably you aren't going to have as much time or as much need for the nuance possibly, so if you have trouble cutting it down or you need thoughts on what would be the most important things to hit, just give us a call.
So I think some of this will come together a little bit easier, hopefully, if we can walk through some scenarios. So we have 4 sample scenario slides that are coming up where we're going to give you sort of a story, a case, and what we're interested in discussing, is a report mandated? Is a report to law enforcement mandated, given the changes under Senate Bill 128? So I will say that neither Terry or I are attorneys, so we're not giving legal advice around this, but we are telling you sort of some of the legislative intent and what the statute is attempting to achieve. What we're telling you is what the law says. That being said, we know that different hospitals and different clinics have their own policies that may go further than what the law says. It may look a little bit different than the law says. There's no way Terry and I can speak to every hospital or clinic policy in the state. And that's why we felt like sort of doing a train the trainer was important. So at the community level, folks can really work with the policies that are existent in their community. What we're telling you is what the law says. If it's applied different in your community, then that's something for your community to work out. But we're telling you, essentially, yeah, what the law says. So we're going to move on. So here's scenario 1. So you all have a question box. So we're hoping you will type in your answer in the text box. So either yes or no, is there a mandatory reporting obligation? And if yes, say why. We're interested in that. So the scenario is we have a 19-year-old female who goes to the public health department for STI testing. So this patient tells the nurse practitioner that she was sexually assaulted 2 weeks ago, and she's worried she has an STI as a result. So that's why she wants the STI test. So the nurse practitioner does a pelvic exam and an STI test. So is that nurse practitioner, is a report to law enforcement mandated? Oh, are we having technical difficulties?
No, I'm not supposed to.
Okay. Okay. So we have one no, we have one yes in all caps, and then we're getting lots of no's. So go ahead and type it into a chat box. So we're just wanting to know what that scenario that's on your screen, 19-year-old STI testing, discloses she wants STI testing because of a sex assault. Is that nurse practitioner mandated to report to law enforcement? Okay, so you guys are awesome. People are all voting. So we've had 2 yeses and the rest are no's. Okay, so we'll go ahead and give you the answer, and then we can talk it through if need be. Let's see. Okay. So the answer is no. In this scenario, a law enforcement report is not mandated. So there's a couple reasons, but we can just stop with really to know. So number 1, again, we're talking about the statute and what's legally bound by this statute in particular. A nurse practitioner isn't statutorily defined as a licensee, so they're not even a mandated reporter under this statute. So that's kind of your number 1 reason that she received care by a nurse practitioner. A nurse practitioner is not a mandated reporter under this statute. Number 2, no evidence is collected. This was just medical care. So those are sort of the 2 first things that you need to know about and why a report is not mandated. People also put that the patient is over the age of 18. That's correct. The other statutes do not apply because this is an adult patient, but not an adult at-risk patient. Okay, so we're seeing some variations. What about the same situation who sees a physician assistant who is obligated? So once again, in this situation, you would just need to know there's no evidence collected. So without evidence collected, and there's no injury either. There was no treatment of injury. So that's also really critical to know. This entire statute is constructed around licensees, as we've defined, which is pretty narrow, treating injuries. And evidence collection. So this is a patient, there was no evidence collection, no treatment of injuries, it wasn't even a licensee, and no other mandatory reporting obligations apply.
Also, answering a separate question that came up, there's a question wondering if fees were covered if there's no evidence collected. At this point, the answer to that is no. The SAFE program, the way the law was constructed, it was triggered by getting a medical forensic exam. Generally speaking, with evidence collection, we're going to take a look at that, but practically it'd be a little challenging for victims because the SAFE program is not a reimbursement program like victim comp. Hospitals bill us directly and we pay. That would be very challenging to incorporate for every public health clinic and every other medical clinic where a person might go to see just for STI testing or something like that. So practically there are challenges with that. We are taking a look at it, but at this moment in time, no, that is not covered. They have to have evidence collected to get their fees covered.
Because if you think about it, it would be pretty impossible to set up a system like that, because patients could have care rights in, their primary care doctor's office. It would just be impossible to set up a system for that, and that's where hopefully funding through public health clinics, Planned Parenthoods, that sort of thing can help with some of those, the costs of the associated medical care. So there was a question, what if the patient tests positive for STIs and is treated by them by a physician. Our understanding of the statute would be that, again, there was no evidence collected. There was no this issue of injuries. What we're looking at is treating physical injuries, essentially, is the legislative intent of this. It's not, that is giving medicine really to treat an illness or disease. That's not the same as an injury. So we would say in that case, even if there's, somebody gets antibiotics, that wouldn't change things because there's not necessarily an injury being treated. That's medicine for an illness. Okay, so, and I guess one thing that I want to stress with this is that even though a report isn't mandated, it doesn't mean that the nurse practitioner does nothing to address the sex assault. And I think that's important for folks to think about. I mean, we certainly would promote and support the nurse practitioner. And this is why I think this is such a community-based issue. Ultimately, that nurse practitioner should absolutely know how to refer that patient. That nurse practitioner should know how to talk to that patient about the sex assault, as well as community resources, as well as options if the patient does change her mind and wants to engage with law enforcement. So we'll talk about that a little bit with the implementation tools as we go forward. But I want to stress that even though a report isn't necessarily mandated to be made, it doesn't mean that the nurse practitioner shouldn't do anything.
Right. Also, we're getting, we do have a SANE nurse on the webinar today, and she's saying that and I'm assuming that's some kind of sexually, their initials that I don't know what they mean. So Bethany, if you'd like to let me know what those mean. But anyway, whatever, certain infections would be required to be reported to the local health department, but only as a sexually transmitted infection, not as an injury. So backing up the theory that that's treating an infection or a disease or a medical care treatment, it is not, chlamydia and gonorrhea. They're not injuries in the physical sense of an injury that would be required to be reported
to law enforcement. Right. Certain STIs may be tracked for public health purposes, where they're reported in a database to the public health department, but certainly not. Law enforcement doesn't need to know if there's antibiotics given for chlamydia, frankly. Okay. So that is first scenario. Okay. Yeah, I know. Yeah, I can take talking through some of this. Okay, so scenario 2, we have a 40-year-old man presents at the emergency department of a hospital. He has a concussion and bruising and states that his partner caused the injuries. He's seen by the emergency department physician. Upon the exam, the patient also discloses sexual assault perpetrated by the partner. He's referred to a SANE, a sex assault nurse examiner, for a medical forensic exam. He wants evidence collected, but he's unsure about proceeding with the criminal justice system. So this isn't just a yes or no, I kind of gave it away. So the question that we're asking you to type in your text box is, what are the reporting obligations? So with this type of scenario, I guess I gave it away, some things are going to need to be reported. What are the reporting obligations in this scenario? So this one might take a little bit more time for folks to think about it. So again, this is an adult patient. He has, he has a concussion, so that's a treatable. That's an injury that's going to require treatment for sure. He's being seen by a physician, and he's having evidence collected. What has to be reported? This is really, sorry about the pause. We're reading all the answers coming in, and there's some great answers. Folks are definitely thinking this through. It seems like everybody gets, stuff is going to have to be reported. We're talking about a physician who's a statutorily bound licensee. He's treating injuries. As some folks pointed out, he's actually treating injuries that are caused within the context of domestic violence, which, as we said at the beginning, is specifically enumerated in the statute, and they're having evidence collected. Folks are also typing in the chat box exactly what we're hoping folks would get, that there's evidence collected, but the patient chooses what type of report he wants. It can either be an anonymous report, it can be a medical report, since he's not sure about law enforcement engagement at this time. So I feel like folks are getting the gist of this for sure. So yeah, so let's kind of walk through it a little bit more. So some things to consider with this scenario in particular is that because the perpetrator is a partner, the patient should also be advised of relevant domestic violence law. So this is a case where we do see intersections of sex assault law and domestic violence law. So you have the statute up on your screen. It's Colorado Revised Statute 18-6-803.6. And what that statute essentially says is that law enforcement is mandated to make a domestic violence arrest when they have probable cause of domestic violence. So, you know, as advocates and former advocates, we would say that the patient should be advised of that law. Regardless of that DV intersection, this patient can still elect to have the sexual assault evidence stored anonymously. But because the physician, as you all said it when you types in your chat box, because that physician is required to report treated injuries, law enforcement's going to be notified about that concussion. Law enforcement's going to be notified about the domestic violence because that's specifically enumerated in the statute. So, you know, we would say with this type of scenario, you know, even if the patient, you know, there's a lot of things that law enforcement's going to be aware of with this case. That this type of scenario, you know, if the patient still elects to be anonymous report, this should really be seen as an opportunity for law enforcement to build trust and gain some rapport with that victim. So if law enforcement is going to be you know, interviewed about the concussion, interviewed about the domestic violence, and about those treated injuries and crimes, this is certainly a case where advocacy services and safety planning should really be integrated. Okay. So yeah, I think we covered that that physician is obligated to report the treatment of injuries, and the sex assault will also be reported, but our patient determines it.
What? We just got a question in on this one. Actually, there's two of them. Hang on. Yeah. When does it become an intimate relationship?
So I can answer. I'll take that one real quick. So when does it become an intimate relationship? That's a great question. Intimate relationship is actually statutory defined within that CRS 1236-135. So it straight up tells you an intimate relationship is, and really it's what to know about that is that it's around a existing relationship or previous intimate relationship. So so we've had scenarios in which, say, a victim goes out on a date with the guy who sat next to her in math class, and she's sexually assaulted that night, and folks say, well, is that an intimate relationship? She went out on a date with him. That would not be statutorily defined at it because there wasn't a previous relationship. Going out on a date does not equate a previous relationship. The sex assault is not the act of intimacy. There has to be previous acts of intimacy.
Right. The other question is, wouldn't law enforcement still have to address the sex assault in their domestic violence report? And the answer to that is no. And the answer to that is also, since 2008, since we've had medical reporting options, and it's granted it's tricky and people handle this differently everywhere. That's part of the reason we wanted to clarify some of this. And we will be coming out with guidelines about this later. I mean, some more guidelines about the Senate Bill 128 specifically. Since 2008, with the medical reporting and being able to get a medical forensic exam without having to report to law enforcement, DV is still a mandatory report, so the DV has to be reported, but the sex assault does not. I mean, the evidence has to be turned over to law enforcement, but it can be stored as a medical report. Interestingly, when we did our survey, we asked which one got primacy, and it totally depended. I mean, some sane nurses reported the whole thing based on a DV. Some didn't report anything based on the sex assault. Some law enforcement officers said there's no conflict between these because the domestic violence takes control. Others said there's no conflict because the sex assault takes control. So clearly conflict. We do address this in the guidelines that will be forthcoming, hopefully in a month or so. We're pretty close on those. So we will address this. This is something that I would suggest that all of your CERT teams, for those that have them, address this. If you don't have a CERT team or an MDT team or something along that line, get your law enforcement, medical professionals, and advocates together and figure out how you're going to address it. But there is no obligation to report the sexual assault along with the domestic violence. In fact, it's much clearer now that there is no obligation under Senate Bill 128.
And I think that the thing that can be hard for folks around this is, I mean, and clearly we know, I think everyone in this webinar is aware of intimate partner sexual violence and how the sexual violence is a component of the DV. So it can be really tricky going forward. I guess what I would really encourage communities and SARTs to think about when you're looking at your applications for this is, so what's the outcome then, right? If you have a victim who does not want to talk about the sex assault and is dead set against reporting the sex assault and is sort of pressured into it before she or he is ready, you know, what happens in that case? What happens is typically maybe there's safety concerns that are now at play for the victim since law enforcement is engaged on a level they weren't able to. But beyond that, you know, these are the cases that victims drop out of the system. And there's a whole array of things that happens when a victim disengages from the criminal justice system. You know, certainly the victim may not be eligible for as many of the, you know, once somebody drops out of the criminal justice system, they may not be eligible for a lot of the different victim assistance programs and that sort of thing. So, you know, I guess I just wanted to put that out there that, you know, we do have kind of convoluted domestic violence and sex assault laws. Colorado is not the only state with that framework. Frankly, approaches from district attorney's offices around sex assault look very different than domestic violence. A sex assault case is highly unlikely to go forward without a victim participating and cooperating. Domestic violence looks a little bit different. So we have different approaches to the issues, and that can be really tricky when they're intertwined. But you know, I think what's important for folks to know is that that the legislature sees sex assault as a uniquely personal crime. And that's why we sort of have this carve out for sex assault. Other injuries, like a concussion caused from DV, that sort of thing still needs to be reported. A licensee still needs to report it if there's treated injuries. And I think that treated injury piece is also pretty important to think about, because we've heard scenarios where you know, a patient just discloses DV to their medical provider and there's no treatment of injuries and that provider still makes the report. That's not statutory obligation. They're obligated to report when they're treating injuries. But, you know, so in that case, to say law enforcement does know about the concussion, the sex assault piece is still anonymous. So we've kind of parsed out these two things that actually were pretty connected. You know, what's important to know is that law enforcement is going to be interviewing that victim about the concussion. And now we have an opportunity through advocacy and through really building rapport and building trust that maybe in a day or two, that victim is going to feel safe enough to give the information about the context in which the concussion happened and bring forth information about the sex assault. But if that victim is not ready to talk to law enforcement about the sex assault, then we think that should be adhered to.
Right, and I can also say the only other thing is, I mean, it's not uncommon. In fact, I'd say it's more common than not that law enforcement will investigate domestic violence without investigating an accompanying sex assault. And I know that prosecutors around the state will prosecute domestic violence without ever prosecuting an associated sex assault. So that's how they're being separated based on the things Karen has talked about understanding that victims don't necessarily want to go forward or talk about or deal with the sex assault, but they're, you know, willing to address the domestic violence. So and they're happening on a case-by-case basis. What we tried to do with Senate Bill 128 and the clarification around sex assault, and what we'll be trying to looking at doing with the forthcoming guidelines, is at least creating some kind of baseline commonality that communities can look at and develop their own solutions. But I think the takeaway from this is that we think it's critically important that your community discuss these issues and figure out how you're going to address them while recognizing the new realities and the new laws around sexual assault and reporting requirements related to that and why they're there.
Okay, so we're gonna keep moving ahead just to make sure we cover everything in the time we have. So scenario 3. So this is a 72-year-old patient presents at a hospital following a sexual assault that was perpetrated by her grandson's friend. She does not want law enforcement involved, doesn't want evidence collected, but she has significant vaginal bleeding and injury that require treatment. Can this patient obtain medical care without law enforcement being notified? So yes or no? So folks are typing in the chat box, and so far everybody has the right answer. Right. With the scenario that you all have, this patient cannot obtain medical care without law enforcement being notified. So you guys all had the correct answer. Oh, we have one yes. Okay, so no, this patient, couple things going on here. This patient's 72 years old. So due to mandatory reporting of elder abuse, which is a different statute, and I will say this patient is going to be treated by a physician. If we're talking about significant bleeding and injury that require treatment, that's going to be a physician that's stepping in. But I did just want to mention that our elder abuse statute is not just licensees. It's actually defined broader. But anyway, what's important to know with a 72-year-old with these types of injuries, that medical provider is going to be mandated to contact law enforcement. If the patient consents to evidence collection, if she changes her mind or that sort of thing, which we do see happen, then she can still request a medical report. She still can be a medical reporting victim. Nobody's going to force her to give information that she's not ready to give or engage in a way that she's not ready to engage. But a mandatory report will be required in this case. Exactly. There's an elder abuse obligation and there were injuries being treated that required treatment. So absolutely. So just to make things crazy, as if folks' heads aren't probably spinning enough, we just kind of wanted to throw a wild card in there. So if we're talking about a 69-year-old, so here we've got, same patient, but now this patient's 69 instead of 72. They're treated by a physician. So what does that sort of look like? Is a requirement? I guess what I would say, I won't confuse folks with the chat box, but if it's a 69-year-old, the elder abuse statute wouldn't apply, but the requirement around reporting injuries believed to have been caused by a crime is still there by the physician. And that physician did treat injuries. So if it's a 69-year-old patient, then yes. So the age cutoff for the elder abuse statute, somebody asked, it's 70 and above is the cutoff. And I know it's really strange with those sort of, 70 looks one thing for one person and very different for another person, but that's therein some of the challenges with laws. Okay, so this is our last scenario, and then we can take a look at questions in the chat box and we'll talk a little bit more about ongoing resources. But this last scenario is a 34-year-old woman who presents at her neighborhood urgent care clinic, and she is seen by a physician. So the patient wants STI and pregnancy testing as a result of a sexual assault perpetrated a month ago. So she just wants to know, did I get an STI and am I pregnant? So is there a mandatory reporting obligation? So far I'm seeing all the right answers popping up. So yay, that's awesome. Okay, so I'll go ahead and, yeah, I think everybody got it correct. You're totally right. No, there's not a statutory reporting obligation in this scenario. Although the patient was seen by a licensee, she was seen by a physician, there was no treatment for injury and there was no evidence collected. And as somebody else pointed out, she's not from, the mandatory reporting of at-risk adults or minors doesn't apply in her case. And I know that especially you all on the front lines, you see the really complicated cases. You see the intimate partner sexual violence cases. You see the cases that there's a lot to parse out. This type of scenario, though, if we kind of look at research of who comes forward following a sex assault, this is actually the most common. A patient who comes delayed, doesn't want to engage in the criminal justice system, doesn't want evidence collected, just wants to make sure that they're okay, and really is just there because they're concerned about STIs and pregnancy. I know you all see the cases with injuries, and I know you all see the ones that are more challenging to interpret. But the majority of sex assault victims don't have accompanying injury, and that's a fact. So for the majority of sex assault victims, hopefully this isn't too incredibly difficult to parse out. But I just want to say that I totally get it. With mandatory reporting, people want very clear rules and lines because not doing it, there can be a penalty. So folks want to make sure they're doing the right thing. They want to make sure they're doing the right thing for their patients and adhering to laws. And advocates want to make sure that they're giving patients the right information and giving victims the right information. So I totally get it. But I have to say that even with these things, it's not always as black and white as folks would like, and that's just not always possible because statutes are subject to interpretation, and there are other policies to consider, i.e. if there's a hospital policy that goes further or clinic policy, that sort of thing. So, so I think what's important is for you guys to have sort of the key points of all this, but to recognize that you know, there may still have to be some problem solving, critical thinking, and parsing out scenarios with your communities to see how it would play out.
I think that pretty much we're going to cover a little bit about resources that are available for you, but just for a quick wrap up, again, there are a couple of important things to remember. One is that basically this Senate Bill 128 created a sex assault subsection to clarify what happens with sex assault mandatory reporting. It didn't touch the existing mandatory reporting laws. That has caused a fair amount of confusion. Also, as we did learn, there is a fair amount of confusion around the VAWA requirements from 2008 and medical reporting, particularly around intimate partner sexual violence, as we saw in the questions we saw in the box today, and how to separate the two and things like that. But the basic thing to remember is medical mandated reporting requirements didn't change, except that there is now a subsection carve out for sex assault. And that section added nurses to reporting for sex assault, and it created anonymous reporting, and it clarified that if no injuries are treated, no report is required. So those are the three primary points. Then you've got within the report to law enforcement, so for the medical mandated reporting, it's based on evidence collection. Within that, there are three types of reports that can be made, and that type of report is based upon victim choice entirely. And again, no evidence collection, no report is mandated unless there are other statutes that apply. We get that this is very nuanced. The way the law is written is very nuanced. The way the mandated reporting statute was written is very nuanced. Injuries, belief that a crime was committed, you know, these specific injuries, that kind of thing. But this hopefully will help clarify it in the realm of sexual assault, recognizing that we still have a ways to go on intimate partner sexual violence. But that's primarily due to the nature of that crime. Does anybody have any questions at this point before we go on, kind of in general?
I'm so glad folks have been using the question box. It's been really helpful for us to kind of see where people are as we're walking through this. And I'm ecstatic that the answers were overwhelmingly right around reporting obligations. There were kind of one or two outliers, but overwhelmingly people got all the right answers. So that's fantastic. I think you guys seem to have a pretty good grasp on this. And the good news is that we're not going anywhere. And we know that whenever there's a law change that happens, it can take some time to implement, and folks can need some tools around implementation. So I just wanted to point out a few things. So CCASA's website is just ccasa.org. If you go to ccasa.org/reporting options, so you guys have that URL right here on your screen, that's what we sort of have as our one-stop shop for all for an array of tools around this issue. So definitely check out that link on our website. We're updating it pretty regularly, so you'll see more things coming up on it. One thing that is up there now, as you can imagine with all these changes, there's paperwork that goes with a rape kit, and paperwork when a victim sort of presents. So those consent forms for evidence collection have been changed to incorporate these different options. So you can download those forms off of our website at ccasa.org/reporting options, /reporting options. As Terry mentioned, you know, we really felt like there's been an array of legal changes over the past few years between House Bill 1020, which created a more victim-centered approach to evidence testing, certainly all these changes that created a larger array of reporting options. So these guidelines that we're talking about, essentially, you could say protocol, you could say guidelines, but it walks through essentially 4 different types of cases. So law enforcement reporting victim, medical reporting victim, anonymous reporting victim, or a victim who just gets medical care only. So what this guidelines document will do is walk through sort of best practices and considerations for each of those 4 types of victims. So that document, we're furiously writing it. We have a really solid draft of it, but again, we want to make sure that it's really vetted by a lot of different folks. So it's going through different revision processes right now, but that will be available at ccasa.org/reporting options when it's available. So that's still coming. What is available now, you'll see in the center of your screen, is the Colorado Sexual Assault Evidence Collection Protocol. This was a project of the Sex Assault Nurse Examiner Advisory Board. And this has been updated to include all of the reporting options under Senate Bill 128. So there's some really great information in here that I think folks need to take a look at for sure. On your left is a brochure that explains all this to victims, because I think the most important thing is that victims understand their answers or their options. So that brochure has been updated to include anonymous reporting and all of these options. So that's something that can be downloaded online via our website, or if you're a CCASA member program, we can certainly send those to your agency in bulk so that you have them. They're being printed right now, so you can go ahead and download it and print it yourself. To get copies in bulk, it may be a week or so. We're also working on the Spanish translation of that, so that should be available as soon as possible. And then at the bottom left of your screen, I have the logo for Futures Without Violence. And, you know, when I talked about how even if a report isn't mandated, it doesn't mean that the medical provider does nothing, and it certainly shouldn't mean that. So Futures Without Violence is a national organization that's done some great work specifically for medical providers around responding to sexual assault, intimate partner violence, in these sort of settings. So they have an array of resources on their website. They have a guide specifically written for OBGYNs on how to talk to patients about these issues. They have a train-the-trainer curricula that any of you could use for sort of community-based folks to go and train medical providers who aren't in this area around these issues. They also have, like reproductive health safety cards that health providers can give out that walk through some of these things. So really, I just wanted to mention that in a situation where a victim is just getting medical care, other statutes don't apply, there aren't injuries being treated, ideally, and we'll address this in the guidelines, we still want to see that victim being given information about the Rape Crisis Center. We want that victim given information about their rights and options. So I think that's important to think about too from a community-based level.
We've had a couple questions come in late. One has to do with kit storage. If an assault occurred out of state, then who stores the kit? The statute actually addresses that and says if it's a jurisdiction where you can't determine where the sex assault occurred, then it's the jurisdiction in which the hospital or agency or entity who conducted the medical forensic exam is located. After that, it would totally depend on law enforcement, whether or not law enforcement in the jurisdiction of the assault is investigating whether they'd send the kit or not. But it would be the law enforcement agency that would be contacted would be where the facility is that conducted the exam. The second question has to do with scenario 2. If the only DV act is the sex assault, how do you deal with that?
Are they treating injuries?
I guess the question then is if there's no other injury, then the question is there a physical injury that's being treated? In which case, is a report mandated to begin with? To be victim-centered in this is to recognize that the victim's choice in this should probably drive it. Since the domestic violence, there are no other injuries out there, so probably you're not looking at a report anyway. Unless there's evidence collection, in which case the victim could choose to do an anonymous report or a medical report or a straight up law enforcement report. So in scenarios like that, I would look to victim choice to drive those that question. That would be a victim-centered response. I also think you'd get much more and better engagement from that victim if that's the way it was approached.
Yeah, I agree. I mean, I think you just always have to go back to, number one, are we talking about a licensee? Number two, a statutorily defined licensee. Number two, is there evidence collected? Number three, are there injuries being treated? Like those are kind of, that's your thought process for walking through these situations. And then kind of overlying all that, what is the victim saying? What is the victim's role in all of this? Because again, we're talking about competent adult patients who are there for healthcare. I mean, that's why they came forward for medical care.
And I guess with regard to licensee, if the only act of the DV was a sex assault, then they're probably seeing a SANE nurse or a nurse who's doing evidence collection. So they're not mandated to make a report on domestic violence under the law. So
Yeah.
that would be the first place to start.
Yeah. Yeah. Good
Any other questions?
Okay, well, I think we're about 10 minutes early, which is always great to finish things ahead of time. But I wanted to make sure you all have our contact information. Any last minute questions, feel free to send them. Terry and I will stay online. But as we mentioned, we really envisioned this with you all being able to take these tools and sitting down with your community, whether it's through a SART, however your community engages as a team around these issues. So we'll be sending out a copy of this presentation. We'll probably send out a PDF as well as just the PowerPoint so you guys can adapt it. Terry and I, we're happy to look over it if you're adapting it and want to make sure you don't lose any of the content. That's totally fine with us. We'll also send you, the accompanying fact sheets, a copy of the bill if you want to take a look at it. Really all of that, but really I want folks to get used to going to that CCASA.org/reporting options, because that's where we'll post the most recent sort of implementation tools as we go along with this. So thank you so much, and we're really excited about the difference this is going to make in your communities. So let us know how it's working, and we know it may take some time, but we're optimistic about the outcomes. So thanks again.
Hey everybody, it's Rosa again. Just wanted to close up with a few things. As Karen mentioned, there will be a follow-up email that I will send to you, and that will have all of the materials that they talked about. Thanks again to Karen and Terry for some great information. Again, this webinar is actually, we're going to do it again in June. So if you missed anything, or if some of your staff members weren't able to attend today, just remember that we're going to do this again in June. We do have a short survey at the end of this webinar, so please fill that out because your feedback is so important to us. And again, thank you for attending this webinar today. Have a great day.